Good morning. Welcome to, or afternoon, depending on what time zone you're in. Welcome to the Western Central Chapter's Ethics for Planning. Today's session will be instructed by Graham Billingsley, FAICP of the Orion Planning Group. I'll give a quick introduction. Well, let me go through my slides here and just do some housekeeping items. For help during the broadcast, you can type a question to Jennifer Cowley in the question box on your GoToWebinar menu. Jennifer Cowley is not in attendance this morning, but it will say her name. Brittany will be assisting us today, so if you'll address any questions to her, that would be great. If you're having technical issues, there's an 800 number that you can call. This is also available on your screen in the box to the right. All participants are muted. To submit questions, please type them into the question box. And the questions will be passed to the presenter actually throughout this presentation. So Graham will give you a little bit more instructions on that when he begins his presentation. There will also be a short survey following the presentation that we appreciate you filling out for us so we have feedback from today's session. For resources, a PDF copy of this presentation will be available on the Utah APA website. That will be available as well as a recording of the session beginning on about Monday. And again, we're the sponsoring chapter for this presentation, so please visit our website as well, the Wyoming Central Chapter, APA.org. There are a number of chapters that participate in these webcasts to provide free continuing education credit, and they're up on your screen. And I'd like to let you know about some upcoming webcasts. On September 8th, we'll have the Economic Development Division presenting what economic development planners should know about eco-industrial development. On September 16th, there'll be successful developer RFP processes, the do's and don'ts. On October 7th, there will be the Wisconsin chapter presenting using GIS to improve planning decisions, part 2. And October 14th, there'll be mobile technology, distracted attention, and pedestrian safety. At the end of today's broadcast, you can claim your credits on the planning.org website. You can select either by activities by date or by the title. It will be under the Western Central chapter. And today's date is August 19th. Ethics for planners. This is eligible for 1.5 CMs for ethics, and those have been approved. So with that, I'd like to introduce today's presenter. Graham Billingsley is currently a partner with Orion Planning Group. He has significant experience covering almost 40 years of practice. He was educated in planning, landscape, architecture, and has practiced in all three fields. For 23 years, Graham was in the public sector. First as Chief Planner for Urban Design with the City of Dallas, Texas. In that position, Graham was responsible for the areas of urban design, historic preservation, as well as numerous neighborhood planning efforts. Graham left Dallas to become Land Use Director for Boulder County, a position he held for 18 years. He had responsibility for a department of 57 employees in 4 divisions, which included planning, building safety, inspection services, GIS, and resource conservation. Graham has developed land use codes, conducted studies or projects in comprehensive planning, economic development, downtown revitalization, demographic and economic analysis, opinion surveying, landscape architecture, historic preservation, urban design, process management, and a plethora of other things. He's acted as an expert witness in numerous land use legal cases, and he's also spoken extensively on planning issues and ethics at national and state conferences. Graham is a previous president of the American Institute of Certified Planners, the Professional Institute of American Planning Association. So among his other many accomplishments, Graham is probably one of the most authoritative people that we can have present today on the ethics. So with that, Graham, I will go ahead and share my screen with you and turn the presentation over to you.
All right, let's see.
And we see your screen.
Welcome, everybody. Glad to see you're all dressed comfortably and sitting attentively. This is always a little difficult to do in this manner, but we'll do what we can through this technology. My hope is that you will feel free to raise a lot of questions, and I will respond. If I can't, Pepper will pull me out of the hole and say something herself. So with that, the agenda for today is to go quickly through the AICP Code of Ethics and Professional Conduct. This is something that when we first instituted this mandatory ethics requirement for certification maintenance, we spent a lot of time on, because we discovered a lot of people hadn't looked at the code for quite some time, often since they had taken the exam. At this point, all of you have been through this in the last couple of years, or you just took the exam, so you're familiar with it. So we'll just touch on a couple of things. I'm going to touch a little bit on some ethical codes of other professions to show how we're somewhat comparable, and then I'll get into some scenarios. Again, I don't have any great desire to go through all of my scenarios, although they've all come up in ethics sessions that I've done around the country. So they're all actually real, and well, I assume they're all real. And they were all about someone's friend who was in that situation. Questions, as I said, please feel free to put your questions up at any time, and we'll get to them. So ethics, several quotes. These were compiled by Dwight Merriam some months back when we did an ethics session. I particularly like Mark Twain's quote. And a lot of ethics really is common sense. I mean, you're facing somewhat marginal ethical issues fairly regularly in your jobs, whether you're public sector, private sector, or whatever. The problem with ethics, and as all of you know when you've taken the exam or gone through the training, is that it's almost never black and white. And usually there's an ability to discuss both sides to a point. Some things are ethical problems to an individual because of the culture in which they were raised, the religion. Others because they have a very well-refined sense of right and wrong in their profession. But a lot of the issues we face aren't all that clear-cut. The other thing is that legally we have an obligation to be aware of local ethics standards. Most states have some form of ethics legislation. Most of it has to do with money in it, and most of them deal only with elected and appointed officials. But still, it's something that you need to be aware of. So the AIA has a code of ethics, has a fairly similar set of principles and structure compared to ours, but it is a little bit different perspective because it is a profession that is mostly just private sector. And that's one of the struggles that we've always had, and that we have a real variety of backgrounds in AICP. The public sector, private sector, academia, and all of these have somewhat unique ethics situations, and it's hard to write a set of standards, rules of conduct, etc., that cover the whole field.
Hey, Graham.
And of course,
Graham.
yes.
I'm sorry to interrupt you. We have a couple of participants who are not seeing the screen, so if you could pause for just a second, I'd like folks to type in their question box if this is isolated to just a few, or if it's everybody that's not able to see your PowerPoint slides. So participants, yeah, there are quite a few that see the screen. So let me just arrow up here to the name of the individual that said they can't see it. Grant Davis. You might need to do some troubleshooting on your end, because apparently it looks like everybody else is okay. So sorry to interrupt, Graham.
No, not a problem. We want to make sure I'm not just talking in thin air. I've lost my train of thought. So AIA Code Ethics. Obligations are to the public, client, profession, colleagues, and environment. These are what they call canons. And a big part of it is balancing that confidential client communication with other obligations. And one that they added a few years ago was fairness and competition with other architects. The SLA Code of Professional Ethics also has a similar structure and also has more of a private sector perspective as the AIA Code does. They have a much greater emphasis on the environment, environmental justice is woven throughout their Code of Ethics. And their public sector employment is addressed principally just through conflict of interest items. And they talk about honesty, dignity, integrity, and fair dealing, which is something that we don't address it directly, but indirectly we do. Engineers, same sorts of considerations. They've added a very strong sustainable development set in their Code of Ethics, which I was really glad to see. And so it is interesting from time to time to take a look at other professions and see how similar they are, and see maybe where they've forged ahead in some areas, like the engineers did with sustainable development, and that maybe we should think about catching up to. For AICP, of course, we've got the Code of Ethics that you're mandated to follow, and we also have ethical principles for all people involved in planning, and those are on APA's website, both of them. So if you're, since most AICP folks talk about the AICP Code of Ethics, it's helpful sometimes to go look at the ethical principles for all planners. So our Code of Ethics is divided in 3 sections. Aspirational, those are the things that we would like to reach, provided it's a perfect world. It's easy. For some reason, we're not in that perfect world yet, as much as planners try. Rules of conduct are the 26 rules that cannot be violated and lead to disciplinary action if they are. And then, since we're planners, we've got half the document, which is procedures, and which is typical. I've done this session, I've done ethics sessions a couple of times with ministers, and their comment is that it only took them 10 rules, and we've got 26, but you know, we explained that we're planners. So our overall responsibility to the public, our primary obligation to serve the public interest. And I think most planners have a fairly strong sense of that and a desire to represent the public, to work for and serve the public interest. We have that responsibility to our clients and employers. And our responsibility to our profession and colleagues. Something that I think a lot of the local chapters have done a very good job of promulgating. And those were aspirational goals. As I said, aspirational. When the code was originally written, these were all combined. But practical application was difficult for some of them, as we all know. However, there were fairly strong. There was a fairly strong sense that the rules of conduct were those that just had to follow. And if you fail to adhere to those rules, then you usually lose your certification in the end, unless you can make amends. Last year, or yeah, I think it was 2010, towards the in the spring, we adopted Rule 26, which some of you may not be familiar with if you haven't looked at the Code of Ethics recently. The problem came up because we had some AICP members convicted of crimes, and we got in a little bit of a discussion with them and their attorneys about whether or not that in itself was enough to have us remove their credential. And so this rule was created to make that clear. The procedures, you have pretty good access to the national office. Paul Farmer, or one of his folks, would be glad to give you informal advice, suggest places to look for solutions, those kinds of things. And then there's a formal ruling in which you request that AICP take action against someone who you feel has violated the Code of Conduct. Those violations are very wide range of things. The serious crime I mentioned before, we've had felony convictions for taking bribes. That's a pretty clear-cut issue of a serious crime. One of the reasons it took a long time to get that rule passed is we had a long discussion about whether a serious crime, whether a felony was automatically a serious crime. And we determined that that wasn't the case. For example, a small amount of marijuana is a felony. It may or may not have anything to do with your ability and your ethical conduct as a planner if you're caught. So we changed it to serious crime, and serious crimes are murder, rape, taking bribes, those sorts of things. The Code of Procedures goes into how to file a charge, how they're investigated, prosecuted, how they're resolved, that sort of stuff. The formal advice can only be given by the ethics officer, which is Paul Farmer, the executive director. That advice is binding. He has to make that finding within 21 days. That then is forwarded to the ethics committee. This is a committee appointed by the AICP president. They can agree with the ethics officer, amend that finding, or overturn it. Once that decision is made, there is the ability to appeal that, and an appeal board is convened in the state in which that member lives or works. If you go to the web page, you'll see this report and it goes, I think, the last 3 years. So we had a fair increase in 2008 and 9 in cases. Last year they dropped off. I don't know the status this year. It will be interesting to see. So with that, I have a number of scenarios which I can go through, but as I requested earlier, if any of you have any pressing matters, or you have something that you've always thought was a difficult situation and you wanted to share that and get my thoughts on it, feel free. But I'll go into some of these and give you what my 2 cents was when they were raised with me. So you're a new planning director, and the city manager informs you that the mayor is up for re-election, and there's an opportunity to help the mayor's re-election campaign. The city manager says that he'll be using his personal time and helping them, and would you like to accept the city manager's invitation to accompany him and help out? This was raised by a planning director. It occurred a dozen years or so ago. And this is one of those in which it's difficult to find a particular rule in our code of ethics that is specific to this. However, it comes up through the concern about appearance of a conflict of interest. This was a rather common situation years ago. Planning directors were often hired and fired based on changes in city council or mayors. There are still a number of planning directors in usually major cities that are appointed directly by the mayor. And so in those situations, as a planning director, you're already tied to the mayor. And so I think that's a little different situation. If you're in a community in which you're hired by the city manager, and the public expects you to be an objective party, weighing pros and cons of applications and amendments to plans and regulations, then once you've stepped into this, even if you've done it on your personal time, you end up becoming tied to the politics of the city, and I think you would lose the public's sense that you're an objective professional. There's a couple of questions that have come up. Do APA members have to adhere to a code of ethics? No, APA members do not. AICP members do. Anybody can belong to APA. You pay your dues. AICP, however, it does require. So there's another question from Katie. Agency I work for was seeking tax increase to support increased services. They're doing a lot of promotion and ask us to talk to friends and family about it. This is somewhat similar to the scenario laid out. I know in some states, Colorado, where I'm from, you're not allowed to talk about any ballot issue election or tax increase or anything of that sort during work hours. And if you talk about it when you're not at work, if you talk about it in your personal time, you cannot represent yourself as, I am the planning director and I happen to think this is an important thing to do. Is something you're not allowed to do in Colorado. I know some other states have some similar regulations. Again, I think this gets back to the question of how does the public perceive it. I don't think it would be an ethical violation provided you didn't use work time or your work cell phone to do these sorts of things. It kind of depends, I think, on whether you're talking to your next door neighbor who, over a barbecue, and they're asking you, what do you think of this, and you give them your opinion, as opposed to you going to a shopping center at a rally and speak for this. That gets a little more confused. So I don't think it's a violation of the Code of Ethics provided you distinguish your roles clearly. I do think that there's a possibility that it will affect how the public perceives you personally. But this is a difficult thing for planners. We work in a very political world. To ignore the politics of these things, I think, is a problem. So you got to balance that. You certainly have the right as an individual to speak your mind on these things, but you have to understand what the possible consequences are.
Graham, I had a request from somebody that you speak up just slightly, so if you don't mind.
Sure.
A little more volume. Thank you.
Not a problem.
It looks like
So
we've
this
got...
is a... Excuse me?
Go ahead. I was going to say, it looks like we have quite a few questions. So
Yeah, we're starting to get some, and I don't mind going to those. But let me throw a couple out there. I think there was a question earlier whether these were mostly public or private sector issues scenarios, and I've tried to divide them. I've worked in both areas, so I think it's important. And this is a private sector issue. As a consultant, and you've been hired by a wireless phone company to process a new antenna array through a local government review. On your site visit, you discover a zoning violation not directly related to your application. How do you handle this? This is actually a case, and it's kind of a tough one. The first thing you have, since you have an obligation as a planner to the public interest, if you think the zoning violation exists, you have some obligation to do something. The solution so there's several things you could do. One is you could go to that local government and say, well, I was going to process this for my client, but there's a zoning violation, which I'm sure you would eventually notice and hold us up on. So, why don't you take care of that first? That probably doesn't serve your client very well. So the suggestion on this is that what you would do is you would tell the phone company, the cell phone company, about this and tell them that you're fairly convinced that it will end up costing them a lot of time and money to get into the process, have this discovered, and then be put on hold. So that they should deal with the issue, if they can, through their contract negotiations with property owner. Um, responses. So there's a situation actually, depends on how the question's asked, how the answer you get to a certain extent. So I was hired to review a development for a government agency. The planner who did the plan for the development asked, after the draft was completed, they had reviewed those recommendations. Those recommendations of changes that I had already sent to the client. That consultant who did that plan then called me and asked if I'd be willing to join him in pursuing an RFP for an unrelated job. So the question is, would this be ethical? Anybody have any thoughts?
Looks like Barb said no, not
Barb
ethical.
said no, not ethical. So the question is one of timing. I think if you've completed your recommendations but the project isn't complete, then this could be perceived as a conflict of interest. There's a concern here that consultant is asking you this in the hopes of when actual final is complete, you will have changed your mind. I don't think in most cases that would occur, but that would be the concern. The facts in this case were we were reviewing a city plan in Saudi Arabia for a new city. The consultant was out of Kuwait, and the request came because they saw in what we had done an ability to deal with the issues that were brought up through this RFP for a comprehensive plan for a city somewhere else in the Middle East. And this was one that I struggled with a bit. So the solution to this was to put it off till that first contract was completely done, and then pursue it afterwards. But when I talked to a number of associates and friends about this, they were pretty mixed. Most felt it wasn't an ethical problem, but a few did because of that appearance issue.
Graham, we had somebody chime in that they missed the answer to the question about identifying the zoning violation.
Oh, okay, sorry. The answer to that was to inform your client, the cell phone company, tell them that the cost in time and money could be fairly significant if they got partway through the process and then the local jurisdiction discovered the zoning violation. So the suggestion was that they, through their contract negotiations with the property owner, get that taken care of, tell them they had to remove it, or else they would find a different property. And that's actually what happened. There's another private consulting scenario, most consultants expect a certain amount of marketing to be done by all of their employees. Larger firms have their own marketing branch, but still there's an expectation. And I, as a small firm, spend a bit of time trying to, I guess market is the best word for it, spread the word about our abilities, capabilities, all that sort of stuff. But this, a woman in Indiana raised this in a session I did there. She was called into her supervisor's office and was admonished because marketing had said that she had not once in the last 6 months bought lunch or any other meal for any of the potential public sector clients with whom she had met. So how do you respond to that situation in which the Code of Ethics makes it fairly clear that you're going to create an appearance of conflict of interest if you as a consultant are buying public sector officials or planners meals? So that's a tough one. My advice was that she inform her boss about the AICP Code of Ethics, give them a copy of it, tell them that it creates this situation, and see what happens. Now, of course, the problem is if you stick to your guns, you may lose your job, or you may not get promoted, or you may be given crappy work assignments, whatever. But I think one of the things that I've learned in my several decades of practice is if you gain respect from your potential clients for being ethical, being honest and upfront, it bodes well in the long run. That sometimes is difficult for people who are not professionals in our field to understand, because their job is to sell. It's not quite as bad as Mad Men, but it's still there. So.
Graham, I noticed a good question from one of the audience that said that what can be done about a planning consultant who represents himself as AICP when he isn't? He used to be, but is no longer. He still uses his AICP credentials on correspondence and application submittals. This happened at a previous place of business. Can anything be done about this? Would you like to address that question?
Yes, this comes up a number of times each year, I'm afraid. Half a dozen or so of these every year. The thing to do is to inform AICP, and they will send a letter telling them to immediately cease and desist. As I said, this comes up fairly often. Usually what happens is that a phone call from Paul Farmer puts an end to it, but if it doesn't, the follow-up letter talking about the penalties will, because once if you're not AICP, then you're not in violation of the Code of Ethics. So this isn't a Code of Ethics violation. This is a different legal situation, and damages can be requested in a civil suit. So AIC is pretty serious about this, and I know just this year there have been a couple of these have come to my attention. One was an FAICP person who's been sending out emails upset that he had his credentials taken away just because he wasn't a member anymore. So it's a fairly straightforward, usually fairly quick process. But if you're aware of it, inform AICP. I agree with Paul's statement that the public sector planners should be declining these lunch offers anyway. They should. If, however, it's been common practice in that town, and they're not AICP, they may look forward to lunch. Pepper, do you see any others?
Sorry,
should I do another one of mine?
I was on mute. You know, there were a couple of follow-up to some of your earlier scenarios. Let me just kind of go back here and pull one. On the cell phone example, if the client didn't take your advice, what would the Code of Ethics require of the consultant? Resign from the job, tell the city, county, other. And then there was another one related to that wanted to know that after you inform your client, is your obligation of an AICP over at that point?
Well, the first one is a question of if your client doesn't take your advice. I guess that kind of relates to the second one too. And this has come up when I've talked about this one before. There is a question of how far do you have to go, and that's in a broader sense something that planners face a lot. I worked for Boulder County, Colorado for many years. The principal driving goal for that county is to keep what's currently there. It's a preserve and conserve approach. So development is generally discouraged. We said no 95% of the time. The comprehensive plan and the intergovernmental agreements with the cities assume that all the development that was requested would be shoved towards those cities and developed, and the population of the county went from 200,000 to 300,000 over a 15-year period because of that goal. But at the same time, as a AICP planner, I have certain obligations for social justice, for example. Because of the policies, affordable housing was not something that was very practical in the county. Still, I felt it was my obligation to make points that would advance affordable housing wherever possible, understanding that a lot wouldn't happen. Now, that's in the broad conceptual planning framework. In this particular case, how far do you go? When you tell your client there's a zoning violation, they're going to probably get in trouble, and it's going to cost them a fair amount if they don't get this rectified. They're a bottom line sort of organization, so it would be very unusual that they not follow your advice in this case. But if they didn't, you could inform them that you intend to make this known to the local jurisdiction, in which case my guess is that you would lose your contract, and that then of course would make you feel very good. Dinner might be more of a problem to buy, but that would be of course the perfectly right thing to do. But once you've raised the concern, then I think you have taken care of most of it. Now, if it gets more complicated if through that process the local jurisdiction doesn't discover the zoning violation, and it's a violation that may be say, polluting a local stream. You know, so you're going to have to weigh how egregious this violation is and whether you think there's a real danger to the public. If it's a home occupation that's got 2 employees instead of the regulations only allowing 1, you're going to have to decide, you know, how important is this to you. And of course, as I said early on, you know, 40 minutes ago or so, these things are never black and white. You can take a black and white approach, which would be, yeah, you're going to have to tell the local jurisdiction if your client doesn't deal with it. But most people will weigh the pros and cons, discharge some of their responsibility, which is to inform your client this is a problem, and that's taking care of it. And I personally would be fairly comfortable with that, although I know there are people who would argue with me about that. Did that answer both of those questions, do you think?
Oh, I think so, Graham. If we get any more follow-up questions, I'll sure pass them along to you. All of a sudden, I'm not hearing you. Are you speaking?
No, I'm not.
Oh, okay. All right.
Some of the questions, sorry.
That's okay. We have one individual that's having some audio problems, so I was trying to do a little bit of a troubleshooting check there.
There's a question about when you're a staff person, the director has AICP and uses it, but the assistant director did not pass AICP and has told other staff not to use their AICP. Your AICP, you should use it. And I would be surprised in that situation you'd get in a lot of trouble if the director is using theirs. I think it's very important for the public to know your AICP. One of the things that I did when I was in the public sector is I gave copies of the AICP Code of Conduct to my elected officials and Planning Commission, Board of Adjustment, so that they had some idea of what I and all of my AICP staff had as code of conduct and that sort of stuff. And I think it's important as a professional that you advertise the fact that you are recognized in your profession, you're certified, and that there are obligations that go along with that. If you don't use your AICP, people don't know that. And of course, if you do know it, most people don't know what AICP means anyway, but some do, and if you take the opportunity to educate people as to what AICP planner is and what that means, then I think it goes a long way. So I would always use it. I don't think, to the lunch question, I don't think it matters if you bring lunch in for the whole planning office or just one individual. The intent is the same, to gain some influence. Then this, of course, food at Christmas is one of those common issues everybody deals with. I had there was a brief time when I worked in Dallas in which it was all refused, sent to a shelter, and that's a good solution. But most of my public sector time, if anything came in, it was available for anyone in the office, including the public that happened to be there. So if we'd get a cheesecake from a consultant at Christmas, it would go out in the lobby. Staff could eat it, the public could eat it, whatever. Okay, I'll go on to another one and wait and see if we got some more questions. So for this has some relationship to the lunch issue, but for many years, a local retailer has given a 15% discount for all municipal employees. That's their way of giving back to the community. And now that retailer's in with an application to expand and wants to, and is requesting a waiver of impact fees. The planning director's husband is an employee of the retailer, and the director and all the staff members are recipients of the discount. So what does the town do in this situation? Since they had allowed this to go on, and actually this is not all that uncommon, or at least it used to be not uncommon when public employees had a little more respect from the public. But the principal thing you have to do here is just be transparent. State what's going on. Explain, that this was a universal thing. It wasn't singled out to any individuals. The staff is professional. The planning commission is going to ultimately make a recommendation or a decision here, and city council is going to make that ultimate decision, and they it will not affect how they act in their capacity. Another one is you've been promoted to run your agency and you had to hire your replacement, which you did. The mayor had been on vacation. They came back to town, calls you and tells you not to hire the person you've already picked to replace you. Once you tell the mayor, he tells you to fire that person. What do you tell the mayor? Some of it depends on the sort of government structure you have. If the mayor is a strong mayor and you don't have a city manager, the mayor can actually fire that person, so you're kind of stuck there. But my advice in these cases always is that you're there to do a professional job. You have hired the person you think best, so you're going to stick to your decision and take the consequences from the mayor that he may want to dish out. There's a question about whether it would be a violation for a public sector planner in one jurisdiction to represent an application in an adjacent jurisdiction, either pro bono or for a fee. I had a planning director from a town in adjacent county, not the county I was director in, represent a neighborhood group on an application in front of us, and I saw no ethical problem. I questioned how he was able to do his job full time and also represent private sector clients. But our meetings were in the evening, and he did a fairly good job representing them. So I don't think it's an ethical problem. If he comes in and talks a lot about the fact that he's the planning director and so, and this is the way they did it there, and this is the way he, then that's getting a little bit in a gray area. But just being a consultant who also happens to be a public sector planner in one jurisdiction, I don't think that's an ethical problem. Okay, you're a planner in a small community. 25 miles from the next community is of a population of over 500. Your downtown businesses are struggling or closing, and the recent loss of a significant employer threatens community vitality and stability. Through a broker friend, you find out Walmart's picked up the option on a large parcel just outside your town. You've seen the negative effect Walmart has had on small independent businesses and other similar communities. And you can plug in a different name than Walmart if you want. And you can anticipate that it will likely cause several businesses, including those owned by the mayor and 2 planning commission members, to falter. So what do you do? Again, this goes back to your obligation. You need to tell people what you know. Now, the mayor, planning commission members may do something silly once they have this information, but you shouldn't have accepted this information from your broker friend without them knowing that you would make this information known. You yourself, I don't think should do anything in particular other than make your city aware of the situation.
And Graham, there's a follow-up comment from a gentleman that said, you're to do, nothing. It's not your job to anticipate a scenario that has not happened yet. Let it play out and then deal with the facts.
Well, I think that's one approach. I think that works fairly well. But on the other hand, if you're aware of something, I think it's important that you inform others who may eventually be affected if the scenario does play out, instead of waiting. Then you got the problem of having known and not told anybody that you anticipated this might occur. Okay, you decide to build a new house and you have carefully selected the builder. Once you moved into the house, you experienced many problems and cannot get them resolved. Later in the year, the builder applies for a zoning change, not on your property. One of your commission members asks you about your opinion of the builder. What do you say? Well, this gets back to what's it mean to be a professional. Your personal problems with the builder have nothing to do with the request for the zoning change. You may be leery as a person as to what that builder will eventually do on that property and whether they'll be, try and shortcut things, and that's sort of a problem. But you've got to look at the standards within your code, determine whether or not the application meets those standards, and then make sure you have the enforcement mechanisms within your code to deal with problems that may come up later. And of course, once the zoning change occurs, that builder may sell to somebody else, may never be involved again. So I think your response to the commission member is that your personal opinion of the builder isn't really relevant to this, and go on from there. And of course, anything you say will imply something. If you say you'd rather not talk about it, they're going to assume there's a problem. If you say that my opinion of that person individually doesn't have any bearing on this, they're going to assume you have a negative idea. But I think it's important to make it clear to that commission member and anyone else that the zoning change stands on itself, not on the individuals who are involved in the request. I like Patty's response, tell the truth. So Always tell the truth except when it's going to get you in trouble. But don't tell a lie. How's that for advice? There's a question about being an appointed official of a local land use board that's advisory to the local planning and zoning commission, and ask whether you can serve as a representative for an applicant before the P&Z on a pending application. We had a situation a number of years ago in which one of our planning commission members was the head of a little league, and the little league came in to ask special use approval for a new ball field complex. He recused himself and then came down off the dais and went to the podium and spoke in favor of the application. The next meeting, the Planning Commission passed an amendment to their bylaws saying that if the Planning Commissioner recused themselves, they had to leave the room and couldn't partake in any way with in any aspect in front of them for an application. To a certain extent, that difficulty, that the uncomfortableness that the Planning Commission feel could happen here, I would suggest that at best, if it's someone that the local Planning and Zoning Commission knows, and I would assume they would, since they're being advised by this land use board, that they not be allowed to have any involvement on any application in front of the Planning Commission as a representative of that application, or actually in opposition to it. Now, this gets tricky if the Planning Commission members happens to live next to a use that is in front of the Planning Commission, a zoning change or a special use or something like that. To then not permit them to speak is a bit of a difficulty. Our advice was always to get their spouse or a friend to speak. They could advise their neighbors what to do and what to say when they got there and that sort of stuff. But our Planning Commission was very strict about it and would not let that person speak even in that situation. I'm going through some of your questions. There's another scenario. As part of your job, you review home occupation permits. Over the weekend, your spouse tells you that her best friend just started a new home-based business for which this person has not submitted an application, nor have you reviewed it. How do you handle this situation without getting a divorce? And that was exactly how the person asked that question. Any thoughts on this one? If you have any questions, type them in exactly where you're typing the question of how should you send them in. So this is a really tough problem, but I think sometimes you have to divorce your personal life from your professional life. I know some planners who would have taken their profession and put it in a higher priority. In this particular case, I think you could suggest to your wife that she might mention to her best friend that she'd be much better off coming in and applying for this instead of getting caught, which could create a problem. But personally, I would probably not pursue this. There is a comment or question here about commission chair is an engineer who represents clients and applications to the Planning and Zoning Commission. So is this bad, or is it just small town interactions that are bound to happen? And one of the problems that we deal with as planners in small towns is that everyone does know everybody. So you have to really consider those differently. If you require that your planning commission recuse themselves if they've had an interaction with the applicant, in some towns you wouldn't have a quorum left because they've all done that. So what you have to do is determine based on how small a community it is, and not small just in population, but how much everybody knows each other. The most important thing is to get on the record what your relationships are as planning commissioners to whoever may be in front of you. They're a neighbor. They're a member of the Elks Club that you're a member of. They're part of your church, any of those kinds of things. And that you feel that you can make an objective decision even though this person is an acquaintance. If it's a relative, then you probably have to recuse them. And if it's just somebody you see in church every couple of months, that's not an issue. But the gray area is how well do you know them, and do you really believe yourself that you can make an objective decision regardless of your relationship with them. And so I think that's the most important. The worst thing is to not admit these relationships and have whoever's upset about it find out later and then challenge the city. This could create some potentially significant damages for the city itself. The application could be overturned by the courts because of that. So there's a number of things to consider here, but it is a very difficult thing to balance in a small town.
Graham, could you repeat your answer on the home occupation scenario? One of the participants missed that.
Well, I said my personal position on that would be that I would suggest to my spouse that she inform her best friend that she could get into a lot of trouble, and so she should apply. But otherwise, I would just leave it at that. If she continues to operate her business and not apply, my personal life is more important than that. And my assumption would be that if I run a pretty good, if the city has a fairly good operation, sooner or later this will be discovered. And having warned my spouse of this eventuality might help a little bit. But it's an impossible scenario. So let's see. Officers of an organization attend a board meeting of an affiliate organization at which time they indicate there is nothing to report regarding a recommendation that is of direct financial interest to the second affiliate organization. Officers are called away to a conference call at which time they discuss the recommendation. There were no confidentiality requirements in the agenda, and the staff reports and other meeting materials were included in the record. Did the officers breach the code of conduct in relation to the second affiliate organization by not divulging an issue of interest to the board of the second affiliate organization before a recommendation was discussed, and more importantly, before it was acted on? Wow, Dan, that's something else. Nothing like Ohio. Since there was no confidentiality requirements and all of the information was included in the record, I would say that there's no breach of code of conduct in relation to the second affiliate organization. It should have been obvious in the record. Now, it should have been done. It should have been stated. There's no question in my mind about that. But since the information was available, and the fact that people don't read the information in front of them, I think it's not an ethical problem. It may be a difficult situation after the fact when people get upset because they weren't aware. So there's another one from Martha. An elected official for a local government had a number of behind closed doors meetings with a powerful, I guess it doesn't matter if they're powerful, but a local developer, large landowner. The meetings were known and reported on in the press, although the details were unknown to the planning staff or the public until they read it in the press, I assume. Eventually, the elected official announced an accord about the developer transferring many acres of land to the municipality as a conservation area in return for approval of a plan for a new large community in an area that would normally not be permitted to develop at that density because it is outside the designated growth management area per state law. The official directed planning staff to create the necessary documents to apply to the state for relief from the state laws to allow this development. The official was clear that this deal with the developer was allowable because the creation of the new conservation area was a significant benefit to the public. Should planning staff work as directed or recommend a more deliberative process? Well, real estate negotiations in most states are covered with confidentiality. The result here probably isn't. The first thing the planning staff should do is probably talk to their city or county attorney. Not clear which this is. If that attorney says that it's legal, then I think you go forward, even if personally you feel it wasn't cricket. And maybe personally you don't think it was legal. But that goes back to one of the earlier scenarios, how far do you have to go? I think you're obligated, if you have any concern, to seek out the best advice you can. And that usually is your attorney, the one that represents your community. If that attorney says no, he doesn't think it's legal, then you turn the whole situation over to them and let them deal with it. If they say yes, they do understand how the elected official interpreted this and they agree with them, then you're kind of hamstrung, even if you think that's an error in interpretation. There's a question following up on the home occupation one. If you're aware of it and you don't say anything, are you subject to losing your AICP? Technically, yes, I guess you would be if someone reported you as knowing about it and not having done anything. Of course, why that person would know about it and not just report the illegal occupation is another question. But I don't think that, given that scenario, with the relationships, I think there's a certain amount of confidentiality you can have with your spouse. I would not worry about losing your AICP over that. There's a question that you are a consultant to a municipality on a controversial issue. The administration changes and takes a different position on the issue that you feel is wrong. Your contract expires and is not renewed. Can you now take a public position against the new policy on this issue? I'm a little confused here. I would assume that you already gave them your advice that this is wrong. They hired you to give your professional opinion on a controversial issue. That also, I would assume, is public record. I don't think that it's going to serve your professional future well to make a big stink about the fact that this community did not follow your advice. And I think that even though your contract's expired, you need to make sure that you follow the letter of that contract. If it does not exclude you from speaking out publicly about your findings, then I think this is a decision you have to make. It, however, changes you from an objective third party giving advice to an advocate, and I question whether you would do that. Ethically, I don't think it's a problem, provided you do it in a professional manner. But personally, I would not do that. I would just be really irritated and eat it. What do you do when it's insinuated that you will be well taken care of with a zoning change? The bribe is implicit. My response was to rescue myself in the process and notify the planning director and the intermediary of my assessment of the implicit offer. The irony was that I was prepared to recommend the change prior to the offer. Well, you still recommend the change because that was your professional recommendation. We had a situation in Dallas in which this same sort of thing happened with the building official. When he told the police chief about it, and they set up a sting operation and took care of that. So that was kind of an interesting situation. But I think you think your idea is right. You tell your superiors about it, but your recommendation is still your professional recommendation, and you shouldn't change that. Are there any guidelines on accepting invitations to evening parties hosted by consultants? In my city, they often invite many planners involved in development review. Personally, I just never went to any of them. I would, on occasion, go to parties hosted by consultants at the national conference or even at a state conference, in which I knew there were a lot of other planners from other jurisdictions going there. No, that's a tough one, and I drew a fairly hard line myself. Ethically, it's not an issue unless you give the appearance that you're favoring that consultant because of that. and you would typically stay away from that sort of thing anyway, because any hiring decision you're involved in should be an objective-based approach with criteria for selection of a consultant and that kind of thing. I like the response from John. If doctors tell people to lose weight all the time, they may choose not to do it. Does the doctor make public announcements calling his clients fat? They don't generally make a public announcement calling a specific client fat, but they do at times talk about the fact they have too many fat clients, and the clients can take it wherever they want. But I think that's a good analogy to the question about whether the city has changed administration and changed direction, whether you should then call them out on it later. We're down to the last 7 or 8 minutes, and I have fairly much wrapped up here.
Grandma,
there was a comment earlier about the scenarios being arcane, and it depends on who you work for, public or private. And I would disagree with that. I having worked 24 years in the public sector and 15 years in the private sector, I think the obligations are pretty much the same. The scenarios that you're hit with are different often, but your principal obligation is to the public interest, and how are you going to serve that? Now, of course, you have to make some business decisions about how strict you want to be about it, and I have personally turned down a number of potential clients because in my investigation and my questioning of them, I have found out that they didn't have the same ethical standards I did. They weren't necessarily looking for the best product to go in the place they were thinking of, and so I said no. And there are other consultants who could handle that, so I didn't feel like I was leaving them in the lurch. But it's a tough one, and it's tough from the other perspective too. In the public sector, you're often put in situations that you don't realize you're in until it's already on top of you. So I don't know what to tell you except that I'm very pleased with the professionals that I deal with most of the time, and I think I have gained more respect of professionals, of planners over my career, as opposed to losing respect for them. So,
Graham, we had one individual submit the same question twice. She's a planning consultant for a small jurisdiction in her area, and she reviews all the building permits and land use permits. She reviews plans from lots of architects, contractors, and engineers, surveyors, etc. And she may need some work done on her fixer-up home in the future. Does she have to use someone that she's never reviewed? She's struggling with ethical versus reasonable.
Yeah, I think it's fine to use somebody that you reviewed. I often went to my building inspectors and asked them who the best plumber was or who the best electrician was, and they'd usually give me 2-3 names. I think it's best if you can talk to 2 or 3 of these people at one time, so that you're then selecting the person that you feel will do the job best for you. And I would suggest that if you hire one of them, you make it clear right up front that this can have no impact or influence whatsoever on any future plans they may be submitting that you'll have to review. But I think for you to go out of town to find somebody is not reasonable. So again, I think a lot of the times ethics comes down to how you handle it, not necessarily what you do, but how you do it. So again, I think in this case, it's reasonable to hire these people. You, of course, have the advantage of knowing how good a job they do from what you've been reviewing. But I also think that it's important that you not just pick one and the others then would assume that you've got some favoritism there, but instead pick 3 or 4 and interview them all and then select from that pool.
Graham, we have a really good question that I think speaks to the last section of the code, which perhaps you'd like to take the remaining time to address. And basically the connection is that, or the question is that in the case about the home occupation, if you choose not to say anything to preserve relationship, and if a complaint were issued with the AICP, would there be mitigating circumstances considered by the reviewing entity, or would the AICP just be taken away? And I think it might be good just to talk a little bit, if you don't mind, about what the process is if someone does file a complaint.
Yeah, if someone files a complaint, then there's an investigation. During that investigation, the planner who's under scrutiny is interviewed, asked to give their side of the story. I hate to say this, but we have on occasion, I know on occasion, people have had a grudge and submitted a complaint related to that grudge instead of a real situation. I know, so anyway, there's an interview that goes on, a lot of questions. The report that Paul Farmer or his predecessor has created on these things is fairly thorough. When the AICP Ethics Commission gets those, both sides of the story are there. Mitigating circumstances are always considered. When action was taken, and I was president for 2 years, but served that 4-year term of president-elect and past president. I was familiar with all of these actions that occurred, and we did not hear after action was taken that they felt they had been mistreated. I think because the ultimate decision comes down to a board of practicing planners who have all been in or familiar with certain situations, those mitigating circumstances weigh heavily in that final decision. So no, it's a hassle when somebody files a complaint. You have to go through that process. It may get dropped after a 15-minute conversation with AICP, but we still think that's the best thing to protect the interest of AICP. But I would not worry about cut and dry decisions.
Great. Thank you, Graham, so much. We're pretty much at the end of our hour and a half. I'd like to thank everybody that attended today. My thanks to Graham for doing an excellent presentation and answering so many questions and presenting so many different scenarios to really get people thinking about how to apply the Code of Ethics in their everyday practice. And I'd like to thank Brittany for joining us today and helping set this up and run tests and do all kinds of things in the background that folks here today probably were not aware of. Incidentally, I neglected to introduce myself at the beginning of the session. My name is Pepper McClanahan. I'm the PDO for the Western Central Chapter. Graham, if you could send the screen back to me, I will post up the information on how to log credits again. I apologize that we didn't get to quite everybody's questions, but I think there'll probably be other opportunities to pose those, and it's
well, I'm
great.
trying to send it back to you. I'm trying to send it back to you, but it's spinning.
Okay, let me see if I can just forcibly accost it. from you.
Yeah, that would be good.
Okay. I think it did. Okay. So up on the screen now, you should see a slide for how to log your credits. And if you have any questions, I'll go ahead and give out my email address if you'd like to address some questions about if you're having difficulty finding either the PDF of the slides, the recording of the slides, or logging your CM credits. You can contact me at pdtwo, that's Papa Delta Tango Whiskey Oscar, at yahoo.com. And again, I thank everybody. Graham, do you have any parting comments?
No, thank you very much for listening. I'll get this PowerPoint presentation up. I'll send it off in the next few minutes. So if anybody missed any questions or were confused by it, it'll be there. Thanks for all the really good questions and comments. They were much appreciated.
Thank you, everyone. And this will end the session.